Again, good morning to both of you. Today's date is May 6, 2021. We have one oral argument scheduled for today. That is the Campbell versus Speelman case. It is case number 29-742. I'm Judge Teodosi. I'll be presiding. Joining me on the panel are Judge Callahan and Judge Sutton. You know, Judge Callahan, I didn't ask you, but could you keep time on this one? Are you ready to do that for me?
I am good to go, Judge Teodosi. Yeah.
All right, thank you. I appreciate that. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. So Attorney Pico, if you are going to reserve time, let Judge Callahan know and she'll keep track of that time for you and let you know as you get close. The argument, as you know, is being visually and audibly recorded, and we are live streaming on our YouTube channel. And the link to the video, of course, can be found on the website. Please mute your microphones when you're not speaking to minimize any distractions. Also, please do not use the names of victims or minors in oral arguments. Not sure that applies in this case, but it's a good public service announcement that we like to make. Having said all that, I can tell you that all of the judges have read the briefs in this matter, and we are prepared to proceed if you are. So, Attorney Pico.
Thank you, Your Honor, and may it please the court. My name is Attorney Rachel Pico, and I represent the appellants, third-party defendants, Carol and Richard Speelman. May I please reserve 5 minutes for rebuttal?
Okay.
Thank you. The issue before the court that has been raised by the appellants is an assignment of, I apologize. The error raised by the appellant in this matter is that the trial court erred as a matter of law by determining that no finding of a change of circumstances was necessary for the appellee defendant, mother Savanna Campbell, who sought to regain custody from the appellants, who are the non-parent third parties previously granted legal custody of the subject minor child, MM, after mother was found unsuitable previously. Ultimately, this case revolves around the legal custody of MM, who was born to appellee, and the now deceased plaintiff, Hunter Morey, who was the father in July of 2011. The appellants are the maternal grandparents of the minor child and have raised her since her birth in 2011 due to substance abuse issues and legal troubles of MM's parents. In May of 2012, the appellants did file a action for legal custody with the Summit County Juvenile Court. And after father Hunter Morey filed his own complaint with the Summit County Domestic Relations Court, seeking to have his parent-child relationship established with MM, the case was then combined and transferred to the Summit County Domestic Relations Court, where it's proceeded since. The original case resulted in an agreed entry in January of 2014, naming father as the residential parent of MM and granting the appellants the right to exercise appellee mother's parenting time with MM on a 50-50 basis, as mother was presently incarcerated at the time for 3 years due to being convicted for aggravated vehicular assault, OVI, and assured clear distance. This agreed entry was later modified in 2015 after mother willingly and voluntarily relinquished custody of MM to father and the appellants, who were then named the joint residential caretakers of MM. Sadly, father died of a drug overdose in 2016, and then several months later, after mother was released from prison, she filed a motion seeking to regain custody of MM. In August of 2016, the trial court denied mother's motion for reallocation, stating that the court emphatically disagreed with mother's assessment that the change in custody would be in MM's best interest, stating that no qualifying change of circumstances existed to warrant a reallocation due to mother's ongoing alcohol abuse issues. The appellants therefore remained the sole residential parents and legal custodians of MM at that time. 6 months later, mother again sought to regain custody by filing another motion to reallocate in 2017. This was based solely on her belief that as mother, she deserved custody. And for a second time, this resulted in mother contractually relinquishing her rights to MM, to the maternal grandparents, the appellants, and mother was granted visitation that was conditioned based off of her maintaining sobriety, attending AA meetings, and her continued treatment with a rehabilitation program. In May of 2019, mother then filed again for legal custody alleging that a change in circumstances had occurred to warrant a change in custody, but soon after claimed that she no longer needed to prove this due to this honorable court's finding in the case of In Re AM, which was decided in 2017. The fact that mother had initially noted that a change in circumstances had occurred and then she went back on that is not necessarily the point of this, but the point is that we then had to brief the issue to the magistrate, given the inconsistency created by In Re AM. The appellants methodically went through the applicable statutes and the body of case law that was decided by the Ohio Supreme Court on this issue, which is controlling, whereas mother relied almost entirely on the single outlier case of In Re AM, which was again decided in 2017. In the magistrate's decision, he then ruled in favor of mother, finding that she did not have to show a change of circumstances only because of In Re AM, and then acknowledged that there were some questions because of this case being such an outlier with regard to the rest of the body of case law. Unfortunately, and albeit predictably, mother's substance abuse issues and legal troubles continued. She was then convicted of 4th-degree felony theft and sentenced to additional 12 months in jail while that case was pending. So the appellants maintained full legal custody of the minor child, and there was an agreed entry entered into by the parties again on April 6, 2020, and then the appellant specifically reserved the right to appeal this issue in the agreed entry, which made that August 20th, 2019 decision a final appealable order reserving right for this appeal. And then the appellants filed their timely notice of appeal. Ultimately, the statutory framework and applicable case law relied upon by the appellants in this matter is very strong. The state of Ohio has long recognized the fundamental liberty interests of biological parents with regard to the care and rearing of their children. However, simply because a parent has a fundamental right does not mean that that is absolute, which the Ohio Supreme Court and legislature have long dictated that trial courts must strike a balance between the rights of parents and the rights of children, as noted in the case of Boyer v. Boyer, which was decided in 1976. This is precisely why before a trial court can award legal custody to a non-parent third party, a trial court must find by a preponderance of evidence that a biological parent is unsuitable as outlined in Re Hockstock, decided in 2002. In the event a parent satisfies one of the In Re Paralis factors, which was decided in 1977, such as abandoning the child, contractually relinquishing rights to the child, which has happened multiple times in this case, or being found totally unable to provide for the needs of the child, then a parent may be found de facto unsuitable. In this case, even without taking into consideration mother's longstanding history of alcoholism, substance abuse, and legal issues, including years of incarceration during MM's so far short life, mother has already been found to be unsuitable pursuant to the Paralis factors by the court, which is precisely why the appellants were granted custody. As a result, when mother sought to modify the existing parenting decree that allocated parental rights to the appellant, she was and should be required to first show a change of circumstances, as she no longer has the paramount rights that a parent would have if they were not found to be unsuitable prior to custody being awarded to a third party. Therefore,
Counsel, are you saying that In Re AM should be reversed by this court, or are you saying that you can distinguish it in this particular case?
We're asking that it be reversed, that it be overturned by this court. It has created an ambiguity in the case law. The vast majority of the case law, in fact, In Re AM is the only outlier of its kind currently in the Ohio in the Ohio common law. The precedents are well established by the Ohio Supreme Court with regard to how these matters should be handled, and that a change of circumstances is not an unnecessary burden on a parent, especially one who has been found previously unsuitable by a court and therefore lost custody to a non-biological third party.
Thank you.
Okay, thank you. Therefore, in order for the court to grant mother of modification of the existing decree, which would have been the January 2018 agreed entry in this case. Pertinent language of Ohio Revised Code 310904 E1A states that mothers should have first been required to show a change of circumstances had occurred for the appellant or MM based on facts that have arisen since the prior decree or that were unknown to the court at the time of the prior decree, before considering whether or not the modification would be in MM's best interest. This is very clearly outlined in the statute. And in the case of In re Braden James, the constitutionality of this statute itself was specifically addressed in a very similar case. In that case, custody of a minor child was given to the maternal grandparents after the parents had been found unsuitable. The Ohio Supreme Court specifically held that the application of the statute and the statute as written on its face is constitutional as applied and does not impose an unnecessary or unfair burden on parents seeking to regain custody from a non-parent third party who has custody. In the case of In re AM, it is clear that this honorable court was sincerely trying to prioritize the constitutional rights of biological parents who had previously relinquished custody to a third party and therefore been found unsuitable. However, it has inadvertently created confusion among the appellate districts in the state of Ohio, imposing one set of rules for parties in the 9th district and another set of rules for parties in the other 11 districts.
Well, it sounds like there may be a conflict that the Supreme Court should take up the issue then.
We're asking that it be corrected now at this juncture, in particular because eventually mother is going to get out of prison again if she's not out already, and it's going to inevitably pose an additional concern for this case and for this family. It is one case. Like I said, the entire body of the case law that's been decided by the Supreme Court thus far has upheld the constitutionality of 310904 E1A as written and as applied. So we would ask that the court, instead of requiring this to go through to the Supreme Court, address it now, and especially considering that it's going to protect MM moving forward, as we expect these types of filings by mother to continue until she attempts to get what she wants or for whatever reason she stops.
Counsel, with that, I'm sorry, Counsel, with that, you are into your rebuttal time. You can keep going if you want, but I wanted to let you know you got about 4 minutes left.
No, that's okay. I will reserve the rest of my time. Thank you, Your Honor.
Okay, thank you, Attorney Pico. Attorney Lysenko.
Thank you, Your Honor. May it please the court, John Lysenko on behalf of appellee Savanna Campbell. I believe that this court is correct in deciding in re AM. And I don't think that this court has created any confusion. The statute, I believe, lends itself to being confused. And the dissent in re AM, I hate to rely on a dissenting opinion here, but the dissent also says, by Judge Hensel, there is an ongoing lack of clarity in the law regarding the applicable standard when a parent seeks to regain legal custody from a non-parent legal guardian. So if we look at the statute, and counsel for appellant cited 310904 E1A, and if we read it plainly, it says that the court shall not modify a prior decree unless it finds, based on facts that have arisen since the prior decree, et cetera, that a change has occurred in the circumstances of the child's residential parent, or either of the parents subject to a shared parenting decree. Now, if this is said, require a change that has occurred in the circumstances of the child's legal and residential custodian, or any other party who has custody, we probably wouldn't be sitting here talking about it. So I think, in my opinion, the problem is not in re AM. And I mean, I can see where the, I understand the appellant's argument about a need for stability in children's lives. And I think the court recognizes that in re AM, and they do try to strike a balance. However, the balance that I believe was struck in re AM recognized the fundamental right of parents and found that requiring a parent in a private legal custody dispute to show a change in circumstances is a threshold requirement. And I'll quote from paragraph 20, places too high a burden on a parent whose child has not been adjudicated dependent, neglected, or abused, or who does not seek to disrupt a child from the custody of the other parent, where the two are on an equal footing. So our position is that there was a balance struck in re AM in the absence of clarity in the statute. And it recognizes that there is a different dynamic involved in domestic relations custody disputes where it's not one parent against another parent, perhaps like in a divorce. And I think it's important to recognize that distinction for different reasons. The appellant appears to me to argue that in re AM is a outlier case, I think is the one way that was described. Well, when the statute is written the way it is, in my opinion, I don't think in re AM is wrong in any respect, even if it is in a minority as compared to other districts' rulings or other case law. I think in re AM's right. And just because that decision doesn't correspond to other ones doesn't mean it's wrong, number one. And especially when the law that we're discussing is not clear. And, you know, if we look at 3109-04, the only time third parties are mentioned is when it says that a court can award custody to a third party if it finds it's not in the best interest to award it to a party. And that's at 3109-04D2. But you know, when I look at 3109-04, the title of it is Allocating Parental Rights and Responsibilities for Care of Children, Shared Parenting. So my other argument is that I don't know that the legislature was really considering private legal custody disputes. When this, and it's even been, you know, as recently as 2011 been amended, and the legislature, you know, they could say in all custody disputes, the legal, you know, the party who doesn't have custody must show a change of circumstances in the child, the legal custodian versus a parent. So my position and our position, the position of the appellant, is that the court in re AM and the trial court in this case recognize the fundamental rights of a parent to be on an equal footing with private parties who have custody versus a parent. And I think that's important. And the court in re AM, this court, I believe made a very well-reasoned decision in light of the lack of clarity in the statute. This statute can very easily cover this situation, but I don't believe it does. And this court, so far, anyway, doesn't believe it does. So I think the decision by the trial court was correct. I think the decision by this court in re AM in 2017 was correct also. It did strike a balance. I'd just like to quickly address something that Counsel for Appellee mentioned, something I went back on something. When I filed the motion at the trial court level, I alleged a change in circumstances. And one reason was that I try to make my pleadings general as a matter of practice, because I've faced a motion that claimed that such a motion should be dismissed because it didn't allege a change of circumstances. So I get into a position where I think I better throw more things against the wall to make sure something sticks. And the issue in this at the trial court level is actually specifically raised after a motion to bifurcate was filed, and the magistrate asked the attorneys to brief this very issue. I didn't go back on anything, and I believe I would have been able to show a change in circumstances, and I understand there's probably a disagreement about that, and but I think that
Mr. Lysenko, what do you make of the argument that the third party stands in the legal shoes with respect to responsibilities towards the child, but does not have the same standing in the other direction with respect to the child and the requirement to show a change of circumstances?
Your Honor, so correct me if I'm wrong, but your question is, should there be any distinction, even though the statute says parent, should that just be construed as legal custodian? Is that your question?
Sure.
Okay. Well, I wouldn't say that that's an unreasonable interpretation of the statute, but I think the statute is subject to interpretation. You know, in fact, the case law that appellant has discussed, I'm sure they're doing just that. But again, my argument is that right now, the Ninth District Court of Appeals have decided it correctly, and with a good justification, I believe. I hope that answers your question. I don't know how much time I have left, but you know,
you have 5 minutes.
Oh, okay. I think this court, in deciding in Ram, recognized the issues of permanency that are involved and discussed them. They discussed the fundamental rights of parents. In fact, that and I believe that this court decided they should be on equal footing in private legal custody disputes. You know, the facts of this case, you know, I'm approaching this as though we're talking about a legal issue. Now, the facts of this case, Counsel for Appellee has talked about it in their brief somewhat a bit this morning. You know, I think this is a legal issue, and you know, I wouldn't say that the facts are irrelevant, but even if we agree with Appellee's position that parents in a private legal custody dispute should have to show a change in circumstances, that's not going to stop people from going to court, because even the standard that they're asking the court to adopt is a subjective standard. It might make some cases go quicker, but people are still going to ask for these custody agreements and decrees to be reviewed. So I don't see that it's going to have the result that the appellee thinks it might have. But I could be wrong about that also. I think that this court struck a balance that will still allow trial courts to evaluate whether there's been a change of circumstances. And they can evaluate whether there's been a change in circumstances when they're considering whether it's in the best interest to change custody of a child. They can still do all that. But if we change things in this case, we're going to set what I would call a bright line rule. And certainly that would be helpful for some people. But I don't think it strikes the balance that recognizes all of the competing interests in a private custody dispute. And with the lack of clarity that I believe exists in the statute, and that I think everyone will, I don't think the statute is clear. And in the absence of that clarity, I think this court's decision in Re M should be upheld. And I think this court has correctly decided those issues. So I'll rest on that, Your Honor.
Any further questions from the panel for Attorney Lysenko? All right, thank you very much. Attorney Pico, then we'll hear from you on your reply.
You have 4 minutes.
Oh, thank you, Your Honor. I think that there needs to be some clarification also made here. In Re AM, opposing counsel is correct. They do mention the idea of an abuse, dependency, and neglect standard. However, that comes from 230103. That is dealing with a case in which you're dealing mostly with the juvenile court determining that a child is abused, neglected, or dependent. It's not dealing with 310904, which is exactly the statute that this matter was decided upon, which deals with private custody actions between parents and also between third parties. And just to, again, clarify, and this is in the brief, 310904D2 specifically provides that legal custody can be granted to third parties. It notes that those individuals can have parental rights and responsibilities as any parent awarded to them. And again, the case law states that in order for that to happen, as in Hockstock, the first thing that needs to happen is that a biological parent or both biological parents, depending on the circumstances of the case, would need to be found unfit or unsuitable. That's what happened in this case. Mother was unfit and unsuitable. And that's also, what happened in Re Braden James, which is very much on point and decided by the Supreme Court. In that case, they did weigh the rights of the parent. They weighed the constitutionality question that was raised by Re AM. They brought all of that to bear. They went through it methodically. They also determined that the stability of a child's life is very important, especially when you've got a parent involved, a biological parent who is unsuitable. When you have that happening, a child needs to have the stability involved. By making sure that a biological parent who was deemed unsuitable must show a change of circumstances, it provides the court with the ability to do what the trial court did in 2016 in their August decision in that case, where they found that there was no change in circumstances for mother. And then in that way, they protected this minor child, MM, at that point from having to undergo an entire guardian ad litem investigation, a full custody battle again, just to have, her life potentially uprooted and to have all of these, questions of where am I going to be, what's going to happen to me, thrown at her unnecessarily. If the change in circumstances is not kept as a threshold in the 9th District, this does continue an outlier case, an outlier finding here that does not take into account the body of case law that was already decided by the Ohio Supreme Court and that has already determined that, yes, parents do have paramount rights up until the point that they are found unsuitable by a court. Once they are found unsuitable, that is when they are on equal footing with those third-party custodians, or those parents that are granted that custody, because they are going to have to show the exact same thing that another third party would have to do in order to modify the plan. That is the whole point here. And the parent should not be treated specially after they've been found unsuitable, and to do so is going to create instability for minor children. In Re Braden James very specifically goes through this and notes that that the 310904E1A is constitutional as applied, and that after careful review of it, it provides stability with respect to judicial decisions, promotes judicial economy, and does not deprive parents of fundamental rights, while also, when looking to the custody of children, trying to promote their best interests ultimately, by preventing them from having to go through never-ending litigation over custody battles.
Counsel, with that, your time is up.
Thank you, Your Honor. Oh,
Judge Teodosia, we can't hear you.
Thank you. I muted myself and I forgot to unmute. So thank you, Judge Callahan. What I was saying was I wanted to thank you both for appearing here today via video, and certainly we had two excellent presentations today. So the court will take the matter under advisement, issue a written decision, which will be mailed to each of you. And it is also posted on the Ohio Supreme Court's website. So thank you again. We wish you a good day. The court is adjourned until Thursday, May 13th, when we will hear oral arguments again. Thank you both again.
Thank you. Thank you, Your Honor.